Good afternoon, everyone, and welcome to this session on special needs planning. I would like to introduce Lizzie Johnson, who will introduce our presenter for this session. Lizzie is the managing attorney of older adult programs with Community Legal Services of Mid-Florida. Are you ready to go, Lizzie?
Yes, I am. It is an honor to introduce Randy Bryan. Randy is a partner with Hoyt and Bryan. I will share some highlights from his impeccable credentials. Randy is a native Floridian from Milton, Florida. He served on active duty in the United States JAG Corps. Randy continues to serve in the reserve component of the Navy JAG Corps as a captain. He has been deployed as recently as in 2008, where he oversaw the detainee legal operations center at Forward Operations Base Camp in Iraq as the officer in charge. Randy has a long legal career. He is compassionate and highly respected in the legal community throughout the state of Florida. He is board certified in both elder law and wills, trusts, and estates, which is rare in Florida because less than 10 people have that distinction. His law practice has been dedicated to elder law, estate planning, probate, and trust administration, including wills, trusts, power of attorney, Medicaid, and VA planning to assist those elders who are trying to age in place at home or transition to a facility like an assisted living or nursing home. He is very active in the community, in the legal community, and his community in general. He is a former president of the Senior Resource Alliance, which is an area on aging agency that distributes funding for many legal and social service providers assisting elders throughout Central Florida. He is the former president of the Florida Bar's Elder Law Section. He's also the past president of the Academy of Florida Elder Law Attorneys and a co-chair of the Florida Joint Public Policy Task Force for the elderly and the disabled. Randy works to protect the rights of the state's most vulnerable citizens. He holds a BS in Business Administration from Nova Southeastern University, and he has his Juris Doctorate cum laude from UM. He graduated in the top 7% of his class. So without further ado, let me turn it over to Randy.
Thank you very much. It is my pleasure to be here with everyone and look forward to sharing some information with you. We've got an hour and 15 minutes, and I am going to try to blow through as many of the slides as I can. I apologize if it feels like a fire hose, but I'm just going to try to get out as much basic information. This program is designed at a basic level, a foundational level. As we go through the program today, I'm going to try to hit on our focus is really going to be, the title of it was generic of the special needs, but it's a little bit broader than just our traditional special needs planning. But what we're going to focus on today is how you provide for and protect individuals that you love who may have a disability or a special need, or who may be in need of long-term care, catastrophic long-term care related issues. So the elder law section of the Florida Bar, the name of it is a bit of a misnomer because it gives the impression that what we do as elder law attorneys is only serve the senior population. But in fact, a lot of what we do does affect people who might be younger that have a disability. So a more accurate description of what we do may be the elder and disability law section, but getting the bar to authorize a name change is like trying to get an act of Congress through. So we started to do that and we tried to do that, but then stopped. And so we are still just the elder law section. But our conversation today will be talking a little bit more broadly, not just about the senior population, but also potentially younger individuals. We're focusing exclusively on our time today on some of the financial eligibility factors, as opposed to the the physical requirements, or the medical requirements, I should say, for some of these special needs programs benefits. We're not going to focus on the in depth on what is necessary to trigger a disability for SSI, or a disability for Social Security disability, or the appropriate level of care for one of the long-term care related Medicaid programs, whether it's the HCBS waivers or the nursing home, the institutional care program. We're not going to focus on the medical requirements for those. We're really going to focus on our time today, the financial eligibility limits. We're going to presume largely that all of the programs that we're going to talk about have that $2,000 asset limit, although there are some that have some different levels, but we won't have the time to get into all of those nuances. So 4 primary areas that we're going to try to hit on in our time today. We're going to start with an important distinction that we have as to what government benefit programs are tied to economic need. So the need-based programs, what I generally refer to with clients as the safety net benefits. And so they're tied, there's a certain level below that we don't want folks to fall financially. And so we have the safety net programs that are there to catch them. Those are the need-based programs versus the government benefit programs that are not tied to economic need. It doesn't matter how much money you have. You can have as much money as you want, but still be eligible for those programs. So a lot of times we'll have clients that'll come in and they'll talk about generically, my loved one receives Social Security benefits or receives Social Security, and then you got to try to figure out what type of Social Security, or they're receiving Medicaid, what type of Medicaid. And so we're going to start with just a kind of an overview of the distinction between needs and non-need based. Then we're going to do an overview of the basic safety net programs, SSI, and then I understand that there was a desire or a need to have more information on the VA safety net program. It's their pension benefit with aid and attendance, or the Medicaid safety net as it relates to long-term care or one of the waiver related programs. So we're going to do an overview of those financial eligibility rules for those programs. Then we're going to talk about special needs trusts and how they come in and how they play a role with that. And then we'll close with just a brief discussion of ABLE accounts. So any one of those topics, well worth significantly more than an hour all by themselves. So that's why I say we're going to go through this pretty quickly, and I apologize for the speed at which I will go through, but I understand you will have the ability to go back and watch these over again. So if I blow through something too quickly, you can always just rewind and then catch that stuff. So we'll start. Government benefit basics, need-based versus non-need-based. Need-based programs are tied to the economic need of the individual. So those are your basic programs like food stamps, legal aid, utility payment assistance, HUD subsidies for housing, SSI, Medicaid, and then Medicaid, obviously a significant number of programs under the primary umbrella of Medicaid, a whole bunch of different programs that all have different financial eligibility requirements, whether it's hospital Medicaid only, or whether we're looking at the long-term care Medicaid programs or one of the Medicaid waiver programs. The VA pension benefit, and there are obviously others, but those are our primary Medicaid benefit or primary government benefits that in order for somebody to receive a benefit under them have to show economic need. Those are our safety net programs. Programs on the right-hand side of the screen are not tied to economic need. You could be Bill Gates, and I guess we got to up our names now because Bill is no longer, and especially post-divorce, will be significantly lower on the richest persons in America. So whether it's Bezos or Gates, he's still got a ton of money. It doesn't matter how much money you have. Your eligibility for these programs is not tied to financial need. So your Social Security retirement benefit, a Social Security disability benefit, or if you have a disabled adult child and that parent then becomes eligible for Social Security, either disability, retirement, or passes away, then that disabled child may step into that Social Security disability benefit. So the entitlement to those Social Security benefits has nothing to do with economic need, just has to do with whether you paid enough quarters into the system and you have enough of those what are called qualifying quarters to be eligible for those programs, and then the disability piece of it for the SSDI. Medicare, not tied to economic need. Once you hit 65, you've got Part A, and then you have the Part B option for enrollment depending upon your work status and where you are with that for Part B and D, or a Medicare Advantage plan. Special education programs, the VA disability compensation benefit. So the disability compensation being different than the pension programs. As you look at these, easiest way that I analogize this for folks as we talk about VA pension program, because over here it's on that left-hand side of this sheet, it is most similar to the SSI program. Definite differences, but the similarities as it relates to economic need are over there. Whereas on the right-hand side, Social Security disability and the VA disability, not tied to economic need for those. This is just a quick shot of where we typically look at the benefits puzzle, and you can see that the primary benefit of SSI, you get a small monthly benefit that we'll talk about, but the primary benefit of SSI is that $1 of SSI benefit gives you automatic Medicaid eligibility for hospital or other Medicaid benefits. So they're connected directly. You don't have to go to the Department of Children and Families and apply for Medicaid. You get $1 of SSI, you're automatically eligible for Medicaid. On the right-hand side of this puzzle, you'll see that the Social Security disability benefit is connected to Medicare. Now, it's not connected as quickly as SSI is, because in order to receive Medicare as a benefit through the Social Security disability, you have to receive your Social Security disability benefit for 2 years, and then, excuse me, you can start having it with your Medicare benefit. There has been movement afoot recently to try to reduce or eliminate that 2-year waiting period for Medicare, but it has not happened yet. So, but they are connected. Social Security disability connected to Medicare, and then SSI connected to Medicaid. And then in the middle of all of that, you've got your Social Security retirement benefits or a survivor benefit that would be available. That's just general income that's going to play a role in your eligibility for SSI, but doesn't affect anything on the disability side. So that's kind of just a general overview of how those different things work together. From a planning standpoint, a recurring thing that we always just that we have to keep in mind when it comes to planning for any of these safety net programs. That's all we're talking about, is the safety net programs that are tied to that financial eligibility. We have to keep in mind 2 different paths that we have from a planning standpoint. The first path is, how do we plan for or protect the assets of the individual, him or herself, who is seeking those need-based benefits, what's often referred to as first-party money. So if I'm the one seeking the eligibility for Medicaid, SSI, VA pension benefit, whatever that program may be, if I have my own money, what are my planning opportunities and options to be eligible for those programs with my own money? The other path is planning for somebody that you love. So I'm not planning for me, but I have a parent, a child, a niece, a nephew, somebody that I love, that I want to provide for and take care of with my money for their benefit. That's third-party Medicaid, or third-party money, or third-party planning. Very, very different planning opportunities and options depending upon whose money it is that we're looking at planning for or needing to protect. And so that's one of the threshold questions that we have to answer for clients as they're coming in to start talking about this, is being very clear about whose money it is. And while that answer might seem like it would be evident, sometimes it's really not, at least evident initially to the client. They don't necessarily understand how those issues work. And we'll talk a little bit more about that as we go through. So with that in mind, now let's do it. We'll start with the SSI program, the Supplemental Security Income Program, as our basic eligibility for criteria and what is necessary to trigger that benefit. So 4 basic criteria: U.S. citizen, you meet the Social Security definition of disability, or you're age 65. The definition of disability is going to be different depending upon whether you're a child, 18, under age 18. Disability definition for a child is different than a disability definition for an adult. For adults, the Social Security definition of disability is really a driver of, can you work? Is there any job that you can perform, what they refer to as your ability to receive substantial gainful activity. That is currently defined as less than $1,310 a month. If there's not a job out there where you could earn that amount, then you don't have that ability to engage in substantial gainful activity from a disability standpoint. And then we have the financial criteria. Your income has to be below $794. So that number adjusts every year with cost of living increases, assuming we have a cost of living increase for that benefit. So to determine that where your income falls, obviously if you have 0, it's easy. But what happens if you have some income during the month? How does that some income apply to the SSI? Well, it's going to depend on the source of the income. So the first $20 of money that is coming into someone is excluded off the top. They exclude the first $20 of money that will come in. And then if you have earned income, so I'm working at Publix or I'm working somewhere and I'm having the ability to have some income, it's just not a substantial amount of income, but it's earned income. I'm doing something to earn it. Then the first $65 of that earned income is excluded, and then 1/2 of your earned income. So effectively, every $2 you earn, only $1 is counted for SSI eligibility purposes. If it is unearned income, somebody hands you $50, somebody gives you $100, that's dollar for dollar. If somebody hands me $50, then SSI says, I don't need that $50 from the government anymore because somebody gave it to me. So they're going to reduce it dollar for dollar. But they do give a benefit for earned income being treated differently. So quick example, we have somebody who's able to earn $317 a month in gross wages. The first $20 is excluded from that. And then the first $65 is excluded because it is earned. So that results in $232 of remaining gross wages, but only half of that is then counted. So $116 is countable. That's deducted from the $794, and the SSI benefit is that resulting difference. So in effect, they're going to get the $794 minus $116 plus the $317. So they'll have more than around $1,000 a month of total income, even though they are receiving SSI. So real quick example of how it runs through. The main thing you want to be careful about in the SSI world is that unearned income. And SSI, Social Security, doesn't count income as just taxable income. It is any money that you receive. So if I hand my son who is receiving SSI benefits $50, that's income to him. It's not taxable income because it's a gift from me to him, but it is income for purposes of SSI that has to be reported, and then his SSI would be reduced by that $50. And then the asset limit for SSI is the same asset limit it's been since the darn program was established, 2,000 bucks, never been a cost of living increase. And I assure you, as you all know, $2,000 today does not buy nearly as much as that bought in 1960s when the programs were established. So definitely in significant need of a cost of living adjustment for these programs, but Congress has to make that happen, and don't see it coming anytime soon. So those are the basic eligibility criteria. As it relates to the asset piece, that resource eligibility, that $2,000 limit, there are some assets that are excluded and not counted towards that $2,000. A home, primary residence, regardless of its value, is excluded for SSI eligibility purposes. A vehicle, regardless of its value, is excluded for SSI eligibility. Small life insurance policies, and when I say small, the face value cannot exceed $1,500. If the face value exceeds $1,500, then any cash value in that policy is counted towards that $2,000 asset limit. Prepaid burial contracts, burial spaces, and then ABLE accounts, which is a relatively newer exemption or exception to SSI eligibility, which will cover towards the tail end of the program today. So those are your basic SSI eligibility criteria. That's what we have to do to become eligible for SSI purposes. So now we're going to shift and talk about what are some of the basic eligibility requirements for the VA safety net program. What is it? The VA pension benefit. So the VA pension benefit, the pension name, it creates a whole lot of confusion in the industry and in the world as it relates to these programs, because a lot of times veterans will hear a VA pension benefit and they turn off because they say, well, I only served 2 years and then I left, or I only served 4 years, or I served shorter time, I didn't retire from the military, which is often the requirement that one presumes is necessary to be paid a pension, is a retirement. This pension benefit has nothing to do with a retirement from the military. It is just a monetary benefit that the VA pays to the qualifying veteran or the veteran's unremarried widow or widower. So it's a financial benefit that is paid based upon their need. The current maximum benefit is $22.95. We'll look at that in a moment. This pension benefit does not require any service connection, which is another huge distinction. So the two most common reasons we hear people kind of turn off in their heads, veterans turn off in their heads as it relates to this program, is either one, I feel like I didn't retire, so I don't think I'm eligible, or two, I'm not disabled. I never have a disability. I served my time. I went home and I'm still okay. So because I don't have a service-connected injury or illness, I feel like I'm not going to be eligible for that help. This one has nothing to do with service connection. It's available to the veteran or the surviving spouse, and there are 3 levels of benefit under this pension benefit. We have the base pension, and then we have an additional benefit if somebody is homebound or housebound, which basically means they can't drive anymore. They're dependent upon somebody else to transport them everywhere they go. Or we have the program for aid and attendance, when somebody requires the assistance with at least 2 activities of their daily living, or they have a cognitive impairment and need supervision. That's the aid and attendance benefit. So the full name for this program is the VA, it's the VA non-service connected pension benefit with aid and attendance. A really long name to get the whole thing out there. Most commonly, it becomes referred to as the aid and attendance benefit that you may hear, but that's where it is coming from, and that's the origin of the program, is the pension benefit with aid and attendance. So what are the threshold requirements? First one is you have to be disabled or over age 65. Most commonly, this pension benefit comes in for those over age 65. But if you're under age 65 in seeking that eligibility, then it would be, you have to show that you are in fact disabled for that pension benefit. The remaining criteria, the 3 criteria for the veteran, are really straightforward. 90 days of continuous active duty, at least 1 day of which is during a time of war, and discharged under other than dishonorable conditions. For our purposes, I'm just going to refer to it as a honorable discharge. Understand that there are some exceptions if somebody doesn't have an honorable discharge, they have an other than honorable or a general discharge, or have some other. There might be some exceptions, but for our time, I'm just going to refer to an honorable discharge because that's the bulk of the discharges that we see from the service. If the veteran has passed away, the veteran's surviving spouse can step into his or her shoes as long as that surviving spouse has not remarried. If the surviving spouse remarries, they cut off eligibility from the deceased spouse. So they need to be smart about that and make sure they marry another qualifying veteran so they don't lose that potential benefit. So those are our threshold requirements. And these are the wartime periods. A lot of times people will say, served during Korea, or they served during Nam, or they're not sure, where their wartime periods, if they overlap. All you have to do is have 1 day during these times of war. The challenge that we see right now is this gap between Korea and Vietnam. So my father-in-law, for instance, his entire active duty Navy service was post-Korea and pre-Vietnam. So he had 3 years of active duty service, but not 1 day of his service overlapped with Korea or Vietnam. So my mother-in-law, as his surviving spouse, isn't eligible for this VA pension benefit because of that, of not having that 1 day. That's the challenge that we see right now with clients. Those are the gap period that we're seeing currently for that period. For financial eligibility for these benefits, there's an income test, a net worth test, and then a look back period. The look back period is to address it's a new issue, a new requirement came in 2018 to address people who were giving away their money in order to meet the net worth rules for VA benefits. So we've always had a look back period for Medicaid, which we'll talk about here in a moment. But for the VA, historically, we didn't have one. That changed in 2018, where we now have a look back period of 3 years for the benefit program. So income wise for the VA benefit, all government need-based benefits start with gross income. What is the gross amount of income you have coming into you each month? Deduct from that income for VA pension benefit, deduct what are referred to as your unreimbursed medical expenses. Whatever is left over is your IVAP, your income for VA purposes. So that's how we determine income eligibility for this pension based program. So give you an example because it's easier to see how that will work for that. First, what is a unreimbursed medical expense? They have a list that they provide, so we can look at that. The key is that those monthly expenses have to be predictable in order to count them ahead of time. Is we have to be able to predict that they will be recurring on a regular basis and aren't just a one-off medical expense that will be there, but a recurring, predictable medical expense. The most significant of these as it relates to this program is number 7, and that's when someone is in need of long-term care related supports or services. So whether somebody's coming into the home, whether we're paying money to an assisted living facility, those are going to be the most, the typical triggers of those unreimbursed medical expenses. So just so you see a quick example of how this income works, we have a single veteran who has gross monthly income of $3,500 a month $42,000 a year. VA annualizes everything. Medicaid converts everything to monthly. The VA converts everything to annual. So we start with monthly and then we annualize. So $3,500 a month of gross income, and then what are those expenses that the veteran has? Paying $148 a month for his supplemental or for his Part B premium, another $250 for the supplemental health insurance, and then he's in an assisted living facility that's costing him $3,500 a month. So his total monthly unreimbursed medical expenses, not his total monthly expenses, right? Because he's still got other expenses that he's probably paying, but we just can't deduct those from the income. We can only deduct the medical expenses. So $38.98 a month in expenses, which is $46,000 a year. There is a annual deductible that you have to take. I'm not going to go into how that's calculated, but the projected expenses for this veteran over the next year is $46,000. So then we come back to that gross income of 42, subtract those projected predictable expenses, leaves us with zero income for VA purposes. That's the goal. We want to get income down to zero for VA purposes, which then triggers the maximum monthly benefit for that single veteran, which is currently $23,238 a year or $1,936 a month. So that veteran will receive $1,936 a month from the VA that's added to the $3,500 a month of their other income, so that $3,500 can go to pay the assisted living, and then the veteran has that extra $1,900 a month for other needs that he or she may have moving forward. So that's how the income piece for the VA benefit works. The other financial component to the VA benefit is the net worth or your resources. So there used to be a very convoluted rule. You can see it. I provide the definition under the old VA rules. The net worth was the amount needed by the claimant to consume for maintenance, taking into account income factors, including life expectancy, number of dependents, potential rate of depletion. In other words, nobody knows, right? We didn't have a bright line like we did for Medicaid that says, if you're over this amount, you don't qualify. If you're under this amount, you do. It was this amorphous calculation that had to be made, and the VA operated like the Great Oz. They drew the curtain and let us look behind it to see how they figured out what that net worth limit was. The good news is we don't have to worry about that anymore. It is now a bright line. The new bright line is $130,773, and that increases annually based upon cost of living adjustments. So the bright line is, if you have more than $130,773, you don't need us yet. You haven't reached the safety net. Keep spending until you get there, then we'll help you. But if you have less than $130,773, then you meet it. And now you've met the net worth test, the net worth calculation. The good news for VA purposes is that $130,000 limit applies regardless of whether you are single or married. So single individuals get the same asset limit as a married couple will receive, unlike on the Medicaid side, which we'll see in a moment, single person, $2,000, married couple, $130,000 and change. So very different asset limit for single individuals under the VA benefit for those programs. So that's your base limit. But like SSI, there are exclusions that the VA has from assets for eligibility purposes. Primary residence is excluded, but there is a limit of 2 acres. So if you have a 10-acre parcel of property that you live on, you're only excluding the value of the home in 2 acres. The remaining 8 acres would be countable towards that $130,000 unless you can show that that remaining excess acreage is not marketable. You can't segregate that piece of property and parcel out and sell that 8 acres because it's not marketable because of deed restrictions or something else that you might have with the property. So home, generally speaking, excluded for eligibility, personal property excluded, vehicles excluded, prepaid burials, burial plots excluded. And then if somebody did give away money prior to that change in the law, that money is not countable either for purposes of VA eligibility, but everything else is. And so we'll note as we get to the Medicaid, one of the primary differences between Medicaid and the VA is retirement accounts. Retirement accounts for VA purposes are not excluded. They are included as towards that net worth, which can really create some challenges for us for VA planning purposes. So accountability includes everything else: checking, savings accounts, retirement accounts, personal property owned for investments, or any other asset that the individual may have. All of those are countable for purposes of that $130,000 limit for VA. So that's a real quick rundown as to what those eligibility criteria are for the VA program. And then we will have a conversation. Now we'll transition into the Medicaid eligibility rules as it relates to the nursing home or the long-term care waiver programs. So that's the sliver of Medicaid that we're going to be talking about, is just the long-term care related Medicaid programs for eligibility. So there are a total of 8 criteria that someone has to meet in order to trigger Medicaid eligibility. The first 5 have nothing to do with how much money you might have or not have. They're tied to what I refer to as just your threshold criteria. Until you can prove these 5 have been met, Medicaid's not relevant. We can't ask Medicaid for help. We can't apply to the Department of Children and Families. All we get to, we just have to sit there and wait until these first 5 are met. First 4 are generally pretty straightforward. You have to have the medical need for a nursing home level of care. You have to be at least age 65 or disabled if you're under age 65, citizen of the United States, resident of the state of Florida. Pretty straightforward as it relates to those 4. We sometimes run into issues with number 1 with level of care, but we don't have time to delve into the nuances of level of care in our time today. That's a medical related issue, and we're really focusing on just the financial criteria. The 5th criteria is where we run into the most issues for long-term care Medicaid. The easiest one is 5A. 5A is not, I meet these 4 and I'm in a nursing home that has a Medicaid bed available. So the long-term care Medicaid program has 2 different paths that we go down. We have nursing home Medicaid with 1 bucket of money, and then we have home and community-based service Medicaid, which is a different bucket of money. And I know somebody else was speaking during the program on the HCBS program, so I'm not going to go into a significant amount of detail on that. Hopefully that information was fully covered in there as it relates to that enrollment, the wait list, and those sorts of things for that program. But that's the issue that we run into with people who are still living in the community but want Medicaid's assistance. They don't want to go into a nursing home. They want to stay in their home or in assisted living or a memory care. The first step for those is for the evaluation, get placed on the wait list, and then when they are released from that wait list, now they've met 5B and we can move on to economic criteria. But that's really all we'll have time to talk about in our conversation today as to the eligibility for the HCBS. Hopefully that was covered in another program, or if anybody has questions as we get to the end, I'm happy to try to answer those for you. The remaining 3 criteria are the financial ones, similar to the VA, right? An income test, an asset test, and then you can't just give away your money and come and ask us for help, a transfer of asset consequence. The transfer of assets for Medicaid eligibility is 5 years. Remember, for VA, it was only 3 years. So the look back period for VA was 3 years. In the 37th month after a transfer, not relevant anymore. But for Medicaid, we've got to wait a full 60 months before a transfer is not relevant. On the income side for Medicaid, we have a gross income number. That gross income number, the income cap that we have in Florida, is $2,382 a month. If income is above that limit, it doesn't mean that there's a ineligibility for Medicaid. It just means there's an extra hurdle that we have to overcome. And that's referred to as a qualified income trust that has to be established in order to take that excess income, run it through the trust so it's not counted for income eligibility. As a quick aside, you could do that through what's called a pooled trust, which we'll talk about here in a moment. We'll talk about some of the issues that's going on right now with pooled trusts, which would also be an option to deal with that. Also, quick aside, not in the materials, but if you have a individual who's not necessarily concerned about nursing home or assisted living expenses, but they have a significant amount of out-of-pocket prescription drug expenses, right? So they've hit the donut hole and they've got all kinds of prescription drug expenses that they need help paying because their Part D premium or their Medicare Advantage program isn't fully covering those things. They have out-of-pockets, copays, deductibles. There is another Medicaid program called the QMB, Qualified Medicare Beneficiary Program, that you can become eligible for. It also has an income threshold, but if you funnel that excess income through the pooled trust, it reduces the income and can trigger that QMB benefit to allow them to get assistance with those prescription drugs. So real quick comments on the income piece of it, but for long-term care Medicaid, $2,382, income trust required if it's in excess. There is no income limit for the spouse who is not applying for Medicaid. Only the person who is applying for Medicaid has an income cap or an income limit. On the asset side of the house, the asset limit, just like for the SSI benefit, for the person applying is $2,000. But for the community spouse, the spouse who is not needing that long-term care assistance, the asset limit is $130,380. So you notice it's a little bit different than the VA. The VA was $770. This is $380. I don't know why there's a difference, but they calculate it a little bit differently for those programs. So those are the financial assets, and then we have our exempt or our non-countable assets. And you'll notice here the primary difference is we have the home is excluded, but there's a home equity limit. There's a home equity cap that is in place on the home for eligibility purposes. You can't have equity in excess of $603,000. No acreage limitation, just equity limitation for a single person. If it's a married couple, no cap. Your home could be, $5 million, and it doesn't matter. Only a cap only applies if you're single. Vehicle life insurance, a little bit higher than the SSI. You get a $2,500 face value protection for Medicaid, only $1,500 for SSI. Prepaid burial, a burial account with no more than $2,500 set aside for final expenses or arrangements. Retirement accounts, exempt as long as the individual is receiving a regular periodic distribution, like a required minimum distribution after age 72. Then the principal value in the retirement accounts are excluded. That's the primary distinction between the VA and the Medicaid. And then ABLE accounts like SSI, ABLE accounts are also excluded. Everything else generally counts. Bank accounts, investment accounts, stocks, bonds, mutual funds, everything else generally counts towards that eligibility limit. So I know that was quick and that was a lot of stuff about the the eligibility criteria, but really wanted to establish that basic eligibility for understanding that. So real quick, there's a couple of questions that popped up here. Clients over age 65 frequently ask about excess assets can be sheltered in trusts rather than spent down. Great question, great segue, because you see here the next slide is special needs trusts. What are they now? And this is lots of different planning options for all of these eligibility programs. For our purposes today, really just going to focus on special needs trusts and doing an overview of how special needs trusts work and the different types of special needs trusts that will be there. So starting with the understanding of basic advantages of special needs trust. The money in those special needs trusts is exempt, is not counted for purposes of the resource eligibility limits that they may be eligible for. So the assets in a special needs trust are there to supplement, to add extra help to quality of life and that will be there, and recognizing that the need-based benefit is a floor, not a ceiling as to need, right? There's a floor below which we don't want people to fall. That's the safety net. But the difference between that floor and the quality of life ceiling can be substantial. Special needs trusts are designed partially to deal with that gap between need and want for quality of life. So providing that continuity, a greater independence, maximizing what their benefits might be, and reducing or eliminating potential guardianship needs in the future. The two categories of special needs trusts, and it comes back to the theme I mentioned at the beginning. Whose money is it are we talking about? There's one type of special needs trust that is designed for people that are trying to protect their own money, first party special needs trusts. And there are special needs trusts created by third parties for the benefit of somebody else, third party special needs trusts. Critical distinction, because very different rules apply depending on whether it is a first party or a third party special needs trust. A first party special needs trust, there's a special exception that is created under federal law, so 42 USC section 1396P, and then the D4 trusts are the ones that are created under that. So under all three of those D4 trusts, which we'll talk about in a moment, what they have in common is that the federal, in passing this law, the government says, we're going to allow you to set aside money for your care to supplement that gap between needs and wants for quality of life. But when you pass away, if there is any money remaining in that trust, you got to pay us back for what we provided in those Medicaid related benefits for medical assistance that we provided for you during your lifetime. That's what all of the first party D4 trusts have in common. So they have different names: payback trust, exception trust, self-settled trust, different names that apply. But what they all have in common is that payback requirement. I mentioned there were three varieties: D4A, B, or C. We're just going to talk today about A and C. The D4B trust we actually already talked about. That's the income trust that is needed for long-term care Medicaid eligibility. It's the only place that one is used, is trying to get somebody eligible for Medicaid long-term care benefits when their income exceeds that income cap. What we're going to talk about today are the D4A and the D4C trusts. So a D4A trust, the irrevocable trust created by an individual, a disabled individual, or by that individual's parent, grandparent, legal guardian, or a court. The addition of the disabled individual, him or herself, being able to create the trust is a fairly recent addition. It happened within the last 3 to 4 years. I can't remember exactly when it passed, but historically, that was not an option. And even though you might have a competent individual, somebody else had to create the trust for their benefit, and then they could put the money into the trust. But now the disabled individual, when competent, can do it on their own. They fund the trust with their own money. That trust is for the sole benefit of that person with a disability. A D4A trust can only be established by someone who is under age 65. Once you hit age 65, this particular trust is off the table. You can't use it anymore. It only works for individuals under age 65. Now, if you have one of these trusts and then you turn 65, the trust is still exempt. It's still protected. You just can't add any new money to it after age 65. Does have the payback requirement. And then after payback, the disabled individual can leave the money to family or anybody else that they would want to benefit from any funds that may be remaining once Medicaid has been paid back. The D4C trust is a little different, it's a little nuanced in that it's referred to as what's called a pooled trust. So a pooled trust is established by a not-for-profit organization that establishes what's called the master trust, which is the overall trust, and then it allows disabled individuals to join that master trust through what's called a joinder agreement. That joinder agreement can be signed by the individual, him or herself. Parent, grandparent, guardian, court are the same options that we had under the D4A. The account is funded with the individual's own money, first party money, also for the sole benefit of that individual. And the assets can be pooled by the trustee. So all of that's where the pooled name comes from, but each individual has their own separately designated account. So their money is theirs in a separate designated account, even though its overall might be pooled for investment purposes with other individuals. That's the pooled trust concept and how they work, from that standpoint. Age restrictions for the pooled trust. This is where we have an issue that's happening right now. So for SSI eligibility, Social Security has always interpreted the pooled trust to be only for individuals age 60, below age 65. So 64 and younger, a pooled trust was available for SSI, but if you were over age 65, Social Security would deem that to be an uncompensated transfer, a gift on the transfer to the pooled trust. So it would not allow you to put money into a pooled trust for over age 65 who is trying to qualify for SSI benefits. Florida Medicaid historically did not draw that distinction. You can be any age and put assets into a pooled trust, and those assets would be protected for Medicaid eligibility purposes. More recently, however, the Department of Children and Families has published a notice of rule change. So they started with just publishing a change in the ESS policy manual without disclosing or notifying anybody. We woke up one day and all of a sudden the rules for pooled trusts was changed without notice. And so we engaged the Elder Law Bar, the task force engaged with the Department of Children and Families, got them to agree to not apply that rule yet until they went through the rulemaking process, which is where we are currently. They did publish we had last week a rule development workshop, and then we anticipate early next week there will be a proposed rule that the Department of Children and Families will publish that will now seek to impose a transfer of asset consequence for individuals who are over age 65 transferring assets into a pooled trust. Lots of questions, lots of unanswered. We're just not, unfortunately, going to have the time today to go through all of those nuances, but I did want to make sure that we brought it up and that you were aware of it. Current applications are not affected by this potential change. We know people are being approved with pooled trusts currently, but we don't know for certain what the future will hold as it relates to over age 65 with pooled trusts. The other distinction between the D4A and the D4C trusts is what happens when the individual dies. The beneficiary of the trust dies. It will depend on the pooled trust that they enrolled with or that they joined. Some pooled trusts, when you pass away, the pooled trust retains 100% of whatever money is left for that trust's charitable purpose, because they're all established by not-for-profit organizations that run these trusts. So some pooled trusts will retain 100% for its charitable purpose. Others will allow you to name a beneficiary to receive if there are any funds remaining, but like the D4A, we got to pay back Medicaid first. And so we got to pay back Medicaid, and then if there's any money left, then it can go to the charity. That's the pooled trust and how those work. The sources of funding of first-party trust. This is where we typically see. So most commonly, we see first-party trusts coming in due to an unexpected receipt of money or just failure to plan for money. So somebody passes away and leaves money to an individual who might be currently receiving Medicaid benefits or SSI, not realizing that that gift is going to cause them to lose that eligibility or put that eligibility at risk. Naming them as a beneficiary, well-intended UTMA accounts always can be problematic, right? Putting aside transfer to minor accounts for my grandchildren with the idea that they're going to use this for their education. One of the potential downsides is we have a grandchild who ends up needing to qualify for SSI. The money in that UTMA account is theirs, and so it can impact eligibility for that benefit. Lawsuit settlements, medical malpractice, personal injuries, a very common source of funds for the D4A trusts, those self-settled trusts. When we have a child support issue for a disabled child who now is 18 and now is an adult for purposes of SSI eligibility, but there is still a child support obligation. If that child support obligation is assigned to by court order and paid to a D4A trust, a self-settled special needs trust, that will not be counted as income for SSI eligibility purposes. But if it's paid to the custodial parent, it will be. So that's where the D4A trust can be very, very helpful for child support obligations that continue after age of majority for a disabled individual. Last issue on the general framework of special needs trusts is don't confuse the authority to create a trust with the authority to fund a trust. So although a parent, a grandparent, a guardian might have the authority to create a trust for the disabled individual, that doesn't give them the authority to take that disabled individual's money and put it into the trust. The funding of the trust is going to be a separate transaction than the creation of the trust. So if the individual with a disability, him or herself, is creating the trust, it's easy. They have competency to create it, they can fund it. But if they don't and somebody else is doing it, then we need to see what authority do they have. And it's either going to be under a power of attorney that might have previously been created or by a court order to allow that funding. But one of those two things is going to need to be there if the individual with a disability, him or herself, is not the one funding the trusts. So those are the first party trust contexts. Then we move into the third party. Third party trusts are much, much easier. Third party trust is your classic estate planning trust. I have someone in my life that I love and I want to take care of, but I want to make sure that the money I leave them doesn't disrupt their need-based government benefits. So instead of leaving that money as an outright gift to them, I leave it in a trust for their benefit that is a special needs, or sometimes referred to as a supplemental needs trust. Because this is my money going into this trust for their benefit, when that disabled individual dies, there is no payback requirement for that trust. I can say when that beneficiary dies, any money remaining goes to, and then I can point where it goes next. So there is no payback requirement for third-party trusts, nor is there a sole benefit rule. So I could create a special needs trust for the benefit of more than one person and have that money available for more than one based upon the needs that may arise. Much more flexible and much easier to work with a third-party trust Third-party trust can either be created as what's referred to as standby. I create it in my will or my trust, but it doesn't actually get funded until after my death. That's when the money comes into it. Or standalone, which is a trust that I create today, and I might put money into it now, even though I'm still alive, or allow other people to point to the trust while I am still living. A standalone special needs trust. Third-party money can come from anywhere other than the individual with a disability, him or herself. So parents, family members, friends, life insurance benefits, gifts, inheritance, lots of places third-party money could come from. And for all special needs trusts, first party and third party, the distribution standard is something that we need to be aware of or look at. There are some supplemental needs trusts that are very restrictive in their standard. The standard is that there can be no distributions if that distribution would impact their need-based government benefits. So if the distribution would reduce, diminish, or eliminate, trustee is prohibited from making that distribution. Or there's a broader standard that says, trustee, you can do any distribution you want, be mindful of an impact on government benefits, but if ultimately you determine that the benefit is more important than the loss, the distribution benefit is more important than the reduction in the SSI, then you got the discretion to do that. I'm not going to limit your ability. And we'll see here in just a second here why that comes into play and why that makes a difference. So anything can be spent from the special needs trust without any consequence on SSI or Medicaid. I shouldn't say anything. Any of these listed expenses can be spent without any consequence. It's easier to say what consequences, what distributions will have a consequence than which ones won't. These are examples of ones that won't. What does have a consequence from all special needs trusts is if there is a distribution for food or shelter when the beneficiary is receiving SSI. If the beneficiary is not receiving SSI, food and shelter distributions are irrelevant. So if somebody is on Medicaid only and not SSI resulting in Medicaid, but Medicaid only, there are no limits on the distributions for the needs of that beneficiary, food or shelter, or any of those other distributions that we listed on the previous page. But when they are receiving SSI, the purpose of SSI is to provide food and shelter to that disabled, to that individual with a disability. So if someone else is providing food or shelter benefits for that individual, SSI is going to reduce the benefit as a result of that third party providing that food or shelter benefit. It's what they refer to as their ISM, in-kind support and maintenance. And this is the exclusive list of food and shelter related expenses. So food, and then these are all your shelter expenses that would be there. Mortgage payments, insurance, rent, electricity, water. If a third party makes payment of any of those expenses, that is an ISM, which will result in a reduction of the SSI. And this walks through an example of how that reduction in the SSI benefit will work. I'm not going to go through it in the interest of time as we're coming up closer on the end, and I want to make sure we have time for to look at it. I know we have a couple of questions over here or any other ones that may come up, but I let you refer back to it so that you can kind of see how that reduction in the SSI benefit would affect eligibility. And so, but real quickly, I will say, coming back to that strict standard special needs trust versus the more liberal standard. Under the strict standard of SSI, if I have a beneficiary as trustee, I have a beneficiary who doesn't have enough money to pay their rent, and the trust says I'm prohibited from making a distribution of rent if it results in a reduction or a diminishment of any of their benefits, that prohibits me from paying the rent for that individual. And now I may be forced to have a homeless beneficiary because they can't afford to pay the rent. And as trustee, I'm prohibited from paying the rent because it would result in a reduction of $284 of their SSI. Well, that's why the broader distribution standard is more helpful, because as trustee, I can say, you know what, I realize they're going to lose $284 of SSI, but that sure as heck is better than them not having a roof over their head. So I'm going to make the distribution, and we're just going to deal with that reduction in SSI. There is now a way that we can eliminate the PMV reduction, that presumed maximum value, or that is in reduction, and that's through the use of ABLE accounts. And this is our last topic for today. ABLE account is a savings account created under the Internal Revenue Code that basically allows us to set aside money in an account that's not countable. It's a new exempt resource for SSI and Medicaid eligibility purposes. Works kind of similarly as a statutory special needs trust. Similarly to an UTMA account is a statutory trust for minors. This is a statutory trust for individuals with disabilities that may need to qualify for benefits. It's substantially less complicated than actually creating a special needs trust and going through the formalities of doing that. Doesn't require an attorney. Go directly to ABLE United and you can set it up there for yourself. Does provide a good opportunities for a high functioning disabled individual with a disability to be able to have access to their own money and to be able to make their own spending, their own spending decisions, have a debit card where they can use the funds as they determine. Good quality of life enhancer for those individuals. Eligibility for Florida's ABLE, Florida, you have to be a Florida resident. The onset of disability had to happen prior to age 26. And then the disability, if you're SSI or SSDI eligible, you're good. If you're not if you haven't previously been confirmed as disabled by Social Security, then you have to submit the documentation to show that you are in fact disabled to establish the ABLE account. The ABLE account is owned by the individual with the disability, can only have one account nationwide. So the individual with disability is only permitted to have one ABLE account. Although many people can contribute to the ABLE account, only one ABLE account is permitted. There are caps on the contribution to ABLE. So contributions are capped at $15,000, regardless of the number of people. It's not 15 per person, but an annual cap at 15,000. Plus, if the individual is employed, they may make additional contributions based upon their income in addition to that $15,000. But non-income contributions are capped at $15,000. And then the distributions from that ABLE account, the money in the ABLE account grows tax-free, and the distributions for a qualified disability expense are not income taxable either, nor do they have an impact on SSI, which includes basic living expenses and housing. So to the extent that there is an ABLE account for that individual, the trustee of a special needs trust can distribute the money to the ABLE account, and then the ABLE account can pay the food and shelter related expenses directly without reduction in the ISM, the presumed maximum value rule, or third parties can contribute to it for those same purposes or those same reasons. So that's how ABLE accounts works. The biggest downside to ABLE, if you will, is that they're really only good, in my opinion, for small amounts. I don't recommend these as primary planning vehicles. If a third party is looking at making recurring and regular contributions, because remember, third party money doesn't have a payback at death, but ABLE accounts do. The ABLE account is subject to a payback to the extent that the probate estate of that disabled individual is subject to a payback. So they got to be over age 55 to have a Medicaid payback, but any money remaining in the ABLE account is paid to the estate of the individual when they die. And that's, so they could still be subject to a payback. So if there's third-party money going into these things regularly, I would not recommend ABLE accounts for those. First-party money works great. Works great for first-party money and can work well for small amounts of third-party money where we're trying to give that individual more control, more autonomy, and working with those things for them to be able to do. So they can work very well with that. So that's the program itself. So hopefully that makes sense. I do see a couple of questions and we still have about 5 or 6 minutes. So let me go through these. I'm going to start for our purposes, since we just finished the ABLE, start with the question, the last question that's on here, which is the related to ABLE. Is the ABLE account the only vehicle that will preserve Medicaid waiver eligibility for a disabled individual childhood disability with self-funded special needs trust after the disability, after they turn 65? So if that the childhood disability, if that individual established a first party special needs trust while they were younger, the fact that they turned 65 doesn't affect eligibility. It doesn't matter. That trust is still protected. It's still exempt. The only issue is, after age 65, does that individual receive money from another source? And if they get money from another source, then we got to look at how we protect that money. If they were disabled prior to age 26, then yes, an ABLE account can work very well, subject to the $15,000 a year maximum contribution. So if they get an inheritance of 50 grand, the ABLE account will help, but it won't solve that issue. We still have to look beyond that. As we sit here today, pooled trusts would still be a viable option for that. And I think pooled trusts will still be viable options in the future. There's just going to be an extra hoop that we have to jump through to prove that the contributions to that trust were made for fair market value, meaning that I have a plan to spend that money over my lifetime. So we're going to have an extra hoop or an extra step we're going to have to go through to have a spending plan for those funds that were into a pooled trust. So ABLE account can work, but it's definitely not the only solution for them. Coming back to the top now, is the cap on the home equity waived if the home is co-owned by the applicant and a non-relative? No. The only time the home equity cap is waived is with spouses. If I own a home, if I am married, the home has no equity limit for my community spouse in that. But if I own it with somebody else, the home equity limit applies, but keep in mind, it only applies to my interest in the home. So if I have a home that's worth $800,000 of home equity and I own it jointly with my son, my equity in that home is only $400,000. So my equity in the home is under the equity cap for that. So it should still be fine under those circumstances. It's only if my equity is above the cap that we run into an issue for those issues. Does the Social Security anti-assignment rule apply to a QIT? And so the anti-assignment rule means that it can't be garnished, or it can't be, nobody else can pull it away from you. Is that what you're referring to on the QIT? The issue we run into with the anti-assignment rule primarily is when we try to change a direct deposit from the individual's account to the income trust directly. And we can run into problems with that because the trust is not the Social Security recipient. And so you can still run into problems with that. I never recommend doing direct deposits in that manner anyway, because you can't turn it off if you need to turn it off. It's much harder to do that. So I never recommend that anyway, but yes, you can run into some issues with that. The VA benefits terminate for a spouse on divorce. Yes, if you divorce, you have to be, as the spouse of a veteran, you have to be an unremarried widow or widower. So during the lifetime of the veteran, the spouse may qualify, but it's the veteran's benefit that would be triggered. If there's a divorce, it's still the veteran's benefit. We don't have a spouse anymore. If the veteran dies, then the spouse receives as long as they don't remarry. And then they get money from Social Security less than 15,000. I don't understand that question. I'm sorry. That seems like a statement rather than a question, and I'm not sure what that is referring to. With that, we're coming up on the end anyway. We're at 2:14 and we're supposed to go to 2:15. So if anybody else has any questions, happy to try to answer them in the less than 60 seconds, but in the interim, thank you very much. I know it was fast. It was a fire hose. I warned you at the beginning to try to get through everything. I'm glad we were able to get through it all. So at least you have some foundation set foundational understanding. If anybody has questions that came up that you'd like to run by me, you can shoot me an email. I don't know that I can do that in here, but Kathy or Lizzie have my email. And so if anybody has a question, happy to shoot me an email and happy to address it. You need to be married at least 1 year. Last question, right under the wire. You have to be married at least 1 year under the VA benefits.
Thank you so much, Randy, for this presentation today. We'll actually need to have you back for a longer one, I think.
Sure, happy to do it. Just let me know.
Thank you.
All right,
Thank
well, have a
you.
good day. Take care.